Your Honor, we would like to reserve 5 minutes.
Okay, you got it.
May it please the Court, my name is John Stimberger, and I, along with my co-counsel Shannon Akins, represent the plaintiff appellant in this case, Jill Marsh. 10 years ago, Your Honors, in 1995, Jill Marsh was an active, healthy, vibrant woman that lived in Orange County, Florida. And over a period of 3 years, she would be involved with 4 auto collisions involving insults and injuries to her body, in which she developed severe forms and debilitating forms of fibromyalgia and myofascial pain syndrome. Your Honors, myofascial pain syndrome, the key word is fascia. It's a membrane under the dermis above the muscles, and it encompasses nerves. When the body injures itself, particularly in the cervical sprain strain, there are micro tears of the fibers, which, if do not properly heal, result in taut bands, almost like chronic
Counsel,
spasms.
isn't the issue for our consideration not whether these syndromes exist? I think everyone concedes they exist. The question, I think, is, number one, to put forth evidence of these syndromes to a jury, was it proper for the court to Fry test them? And number two, and as a subset of that, is there sufficient evidence to pass the Fry test that there is a relationship between a significant, provable relationship between trauma and fibromyalgia and the other syndrome? I mean, at the end of the day, isn't that what we're here about?
That's precisely the issue, Your Honor.
So I think we all agree, at least based upon the parties' briefs, that these syndromes exist and that they're real. The question is, should they have been Fry tested, and did the court reach the right conclusion?
They should not have been Fry tested, Your Honor, and that's precisely the issue in this case. And really, under Florida law, there's really a two-step process that's not delineated, but it's articulated in the cases. First, we ask, does Fry apply? And if, in fact, the testimony is pure opinion testimony based upon the training, education, and experience of a physician, let's say in the...
How is a trial judge supposed to handle it if you don't have a Fry test? I mean, if he decides he doesn't want to, if there's an objection made to this testimony, I mean, he's obligated by law to conduct a Fry test, isn't he?
No, he's not, Your Honor. The first inquiry is, does Fry apply? And that's the threshold question under Florida law that is different in many other of these cases that we see. In many other cases, they don't ask whether Fry applies, they automatically apply Fry. Here, if there's pure opinion testimony, for instance, the treating physicians and the experts, they didn't rely upon any new or novel scientific tests or techniques. They rendered pure opinion testimony based upon an examination of the medical records. They examined the patient. They took a history of the patient. They learned that she did not have symptoms previously and that she now has incredible symptoms after the insults. And so, Your Honors, we think that the first argument we would make to this court is that it's incumbent upon the court to return to the original public policy reason behind the adoption of Fry. And the original public policy reason is to weed out, as Fry said in 1923, junk science, which is in the twilight zone of scientific development.
Well, you know, I must tell you that I have a hard time understanding, and I'm asking this question in the hope that you can explain to me how pure opinion testimony in a legal sense differs than just sort of pulling an opinion out of the air. And by that I mean, basically what I understand the cases say is if an expert testifies based upon his or her experience, training, and personal observations, that falls into the realm of pure opinion. But how does that expert arrive at those observations? I mean, presumably the expert in this case went to medical school and has done the continuing education things, read journals, does the things that good professionals do to keep up. So I guess the problem I'm having is it doesn't seem to do the law or juries much good if we simply let an expert come in and say, I'm a doctor, I didn't rely on any specific studies, but I think that she's got X, Y, Z, and it was caused by the accident. I mean, how does what we call pure opinion testimony differ from just essentially a wild guess or just pulling an opinion out of the air and say, I'm a doctor and I've seen this before?
Sure. Your Honor, expert testimony, as the jury instruction says, either can be accepted or rejected if they don't rely upon some new or novel scientific gadget or test. When there's scientific evidence, there's an automatic aura of credibility, a legitimacy that's assumed in the test, and the test can't be cross-examined. The witness can be cross-examined, but if he's relying upon some gadget, then that thing itself, that thing from which the deduction is made, has this aura, and that triggers the Frye scrutiny. So that is the distinction, Your Honor.
But my concern here is that, you know, at the end of the day, the expert here was prepared to testify, A, that your client had fibromyalgia, and B, that it was caused, directly caused by this multitude of accidents that she was related to. And it seems to be that second question, you know, what good, when we talk about public policy, what good does it have to have someone who is an expert witness come in and just make a claim that doesn't enjoy any widespread support in the relevant community?
Your Honor, the law in Florida is not that proposition. The law in Florida is that where the expert is rendering this opinion testimony, which he's subject to cross-examination, he's subject to being exposed if he is in fact stretching, that can be done as any other witness could be. The jury's instructed, in fact, that the witness can be ignored if he's not credible. And so, unless the expert's relying upon this testimony, something new and novel, some scientific evidence that triggers Frye, then Frye doesn't really apply. And furthermore, Your Honor, let's assume this case does want to subject the methodologies of these experts to Frye. What, if anything, they did rely upon is a differential diagnosis. And this is the process whereby a physician rules out other symptoms. They thought that Jill Marsh had multiple sclerosis. They thought she had lupus. They did blood tests, blood work.
Well, the problem isn't the diagnosis of the condition. The problem is the testimony about its cause.
Yes, Your Honor.
So this is not a differential diagnosis issue. It's a question of whether this physician is competent to testify as to the cause, isn't it?
No, it's precisely because the differential diagnosis was post-traumatic fibromyalgia.
Right?
That was the differential diagnosis.
The problem is his testimony that it was caused by the accident.
And that testimony, Your Honor, was reached by a differential diagnosis. They ruled out the fact that it could have been hereditary fibromyalgia. They ruled out a number of other things, and they narrowed it down to post-traumatic fibromyalgia.
Well, but doesn't that really take the concept of differential diagnosis a little bit further than it's supposed to? Differential diagnosis, I understand, is you start with all the universe of things that it might be, and you start scratching things off as you say, well, you know, I've done this exam, I've done that, so it can't be this, can't be that, can't be this. And once you're down to one thing, you say, well, since it's not everything, all these other things, it's this. But my question is, for purposes of what his diagnosis is here, is his diagnosis, for our purposes, she has fibromyalgia? Or is his diagnosis that she has post-traumatic fibromyalgia? Does it make any difference in the treatment perspective that it's post-traumatic, or even in the diagnostic perspective? You know, if you've eliminated all these other things, what difference does it make from a doctor's perspective, from the treatment perspective, that it's post-traumatic versus just, she just got it?
I believe that the treatment would still be the same, Your Honor, and I'm not sure that it would be different. But the controlling case that this court, and I would submit there's really one case that this appeal should turn on, and that is Costello versus DuPont. And in that case, this is a Benlay case where a pregnant mother, child had a rare birth defect as a result of being exposed to the fungicide Benlay. But even in this case, the court, they used various studies, 3 different studies, and the court even recognizes that these studies were inconclusive to prove a causal link. And the court says that it didn't matter, that in fact the objections were to the conclusions themselves, not to the methodologies. Your Honors, the defendants would have us believe that we need to have some kind of an exacting, airtight scientific study in order to admit evidence on causation, and that is simply not the law in Florida.